Chairman Goodlatte, we thank you for being here. Look forward to your remarks.
Well, Jeff, thank you very much. And first, my sincere apologies to all of you. It's easy to blame Washington traffic, but you all got here well before I did. And I'll just blame myself and my navigation skills, maybe a little bit on my GPS. But
Our very high-tech podium sign.
there we go. A quick name change. But it's a pleasure to be with all of you, and I want to thank you for taking the time to hear about this legislation, which I'm very excited about, and which we have spent all of this year. In fact, even before I became chairman in January, we were beginning to formulate ideas about how to undertake this. And this has been a collaborative effort, not only bipartisan in the House, but also bicameral, because we have worked very closely with Senator Leahy and his staff in working on this, and with the executive branch, with the PTO, with the White House, in consultation with them, to try to assemble the best ideas that we could put together to address patent litigation reform. This is an issue that a year ago most people would have thought would not be likely to happen, just 2 years, now almost 3 years after the passage of the America Invents Act, the first major patent reform legislation in my lifetime, and some say the most important patent reform legislation in about 170 years. To go at it again just 3 years later is pretty amazing, but there is a strong coalition building in support of taking additional steps. So first, I'd like to thank the American Enterprise Institute for putting together today's conference, and to all of you for being here this morning. Today I'm going to talk to you about an issue that is central to U.S. competitiveness, job creation, and our nation's future economic security. I'm talking about American innovation and our patent system, and more specifically the patent litigation reform legislation that I, along with a bipartisan group of members, introduced yesterday. The Innovation Act, H.R. 3309, takes meaningful steps to address the abusive practices that have damaged our patent system and resulted in significant economic harm to our nation. The Innovation Act builds on our continued bicameral and bipartisan collaboration on this important issue. During the last Congress, we passed the America Invents Act. That bill was the most significant reform to the patent system in my lifetime, and many view it as the most comprehensive overhaul to our patent system since the 1836 Patent Act. The AIA modernizes our patent system and sets it on the right path for decades to come. The goal is higher quality patents that can stand up to review, setting the bar higher so that quality control starts on the front end rather than relying on the courts. But the AIA was in many respects a prospective bill. The problems that the Innovation Act will solve are more immediate and go to the heart of existing patent quality and certain abusive practices taking place in our courts. The U.S. patent system is designed to be fair, meeting our international obligations and not discriminate against any field of technology. The strength of the U.S. system relies on the granting of strong patents, ones that are truly novel and non-obvious inventions, those that are true innovations and not the product of legal gamesmanship. While the AIA paved the way for higher quality patents on the front end, there were a few issues that were left on the cutting room floor during the last Congress that could help go more directly to the immediate issues surrounding abusive patent litigation. Abusive patent litigation is a drag on our economy. Everyone, from independent inventors to startups to mid and large-sized businesses, face this constant threat. The tens of billions of dollars spent on settlements and litigation expenses associated with abusive patent suits represent truly wasted capital that could have been used to create new jobs, fund research and development, and create new innovations and technologies that would promote the progress of science and useful arts. Within the past couple of years, we have seen an exponential increase in the use of weak or poorly granted patents to send out purposefully evasive blanket demand letters or file numerous patent infringement lawsuits against American businesses with the hopes of securing a quick payday. Many of these abusive practices are focused not just on larger companies, but against small and medium-sized businesses as well. These suits target a settlement just under what it would cost for litigation, knowing that these businesses will want to avoid costly litigation and probably pay up. Such abusive patent suits claim ownership over basic ideas, such as sending a photocopy to email, podcasting, aggregating news articles, offering free Wi-Fi in your shop, or using a shopping cart on your website. Something is terribly wrong here. The patent system was never intended to be a playground for litigation, extortion, and frivolous claims. The Innovation Act helps to address the issues that businesses of all sizes and industries face, from patent troll type behavior, and aims to correct the current asymmetries surrounding abusive patent litigation. Our bill keeps in mind several key principles. First, we are targeting abusive patent litigation behavior and not specific entities or attempting to eliminate valid patent litigation. When we use the term patent troll, it is more of an adjective describing behavior than a noun. Our goal is to prevent individuals from taking advantage of gaps in the system to engage in litigation extortion. Second, our bill does not diminish or devalue patent rights. The patent system is integral to U.S. competitiveness, and we must ensure that any legislative measure does not weaken the overall patent system or violate our international treaty obligations, and that it comports with the Constitution. Third, this bill strikes the right balance, pushing for robust legal reform measures while protecting property rights, promoting invention by independents and small businesses, and strengthening the overall patent system. Abusive patent troll litigation strikes at the very heart of American innovation and job creation. That's why Congress, the federal courts, and the PTO must take the necessary steps to ensure that the patent system lives up to its constitutional underpinnings. But there are some who have commented as to whether Congress is even allowed to put forward legislation to address abusive patent litigation and must instead defer completely to the courts. Let me be clear about Congress's constitutional authority in this area. The Innovation Act puts forward provisions that are not only in line with Congress's constitutional authority, but with our constitutional duty. By the terms of the Constitution, it is up to Congress to decide whether and how to grant any, I'm having a bad morning. It is up to Congress to decide whether and how to grant any of the federal court's jurisdiction to decide cases with the sole exception of the Supreme Court and its constitutionally guaranteed original jurisdiction over certain limited subjects. Our founders recognized that Congress's power to constitute courts is a power to prescribe the mode of trial. That's Alexander Hamilton in Federalist number 83. The first Congress not only limited the jurisdiction of the federal courts, but it also dictated what procedures the federal courts would employ. And the Supreme Court has long recognized that the regulation of court procedure falls within the legislative function. The court has noted that Congress's power over federal court procedures derives from its power to constitute the lower federal courts. Indeed, the Process Act of 1789, enacted by the first Congress, which consisted of many of our founders, including James Madison in the House of Representatives, dictated precisely what procedures would govern in federal courts, a power Congress is recognized as having under its legislative powers. But that is not to say that the Supreme Court does not have a role to play in addressing abusive patent litigation. They have a strong role, and we welcome the increased interest that the court has shown in taking up patent cases in recent years, and that reflects the growing importance of IP to our nation's economy and future growth. It also reflects the growing problems that the court faces due to inconsistent application of the law in lower courts and abusive patent litigation in general. A few weeks ago, the Supreme Court announced that it will review 2 cases relating to attorney fees and the exceptional case standard under Section 285 of the Patent Code. Those cases are important, but they also drive home the point that the existing provision is antiquated, unclear, and restrictive. The Innovation Act includes a new, modernized version of Section 285 that is clear, fair, and will ensure consistent judicial determinations. Since the enactment of the AIA, the Patent and Trademark Office has worked to ensure that there is greater transparency surrounding patent ownership. They have even developed rules around real party in interest, but much of their work hinges on actually receiving the information. Today, when a patent infringement suit is filed, the courts are required to provide transparency information to the PTO, but that rarely happens. The Innovation Act includes a transparency provision that requires the plaintiff to provide this basic information to the PTO, the court, and the opposing party. It also requires the patent owner to keep these records updated, and if not, they forego enhanced damages and fee shifting. The Innovation Act also includes provisions requiring heightened initial pleadings, requiring parties to do a bit of due diligence up front before filing an infringement suit is just plain common sense. It not only reduces litigation expenses, but saves the court's time and resources. Greater transparency and information is a good thing, and it makes our patent system stronger. The Innovation Act also provides for more clarity surrounding initial discovery, case management, joinder, and the common law doctrine of customer stays. The bill's provisions are designed to work hand in hand with the procedures and practices of the Judicial Conference and the courts, ensuring that the final rules and the legislation's implementation in the courts will be both deliberative and effective. The bill also provides for small business education and outreach by the PTO and includes necessary improvements and technical corrections to the America Invents Act. Together, the various provisions in the bill will work to measurably reduce abusive practices in our patent system. Today, I am calling on each of you to help work with us as we build momentum towards enacting this important bill. Together, we can take steps toward eliminating the abuses of our patent system, discouraging frivolous patent litigation, and keep U.S. patent laws up to date. Together, we will ensure that the days of those who engage in patent litigation extortion are numbered, and together we will pass patent legislation that will help fuel the engine of American innovation and creativity, creating new jobs and growing our economy. Thank you so much for your patience and for allowing me to present my ideas regarding patent litigation reform.